What if I told you the lawyer flying on a private jet with Odell Beckham Jr. after beating Nike in court is the same guy helping UGC game creators protect their rights and avoid million-dollar lawsuits?
A big one we had recently was we represented Odell Beckham Jr., the NFL player. He actually went to trial against Nike. It was a dispute over a shoe endorsement contract. We prevailed. He actually flew us out to Las Vegas on a private jet afterwards. He was so happy, which was
my God.
Yeah, pretty cool. Partying in Las Vegas with OBJ.
From Grand Theft Auto ownership battles to a Fortnite legal fight that could change UGC forever, this episode is packed with behind-the-scene legal stories you've never heard.
Games has a game called Crazy Red vs. Blue. Jogo Studios has Super Red vs. Blue. So you can't copyright the concept of red versus blue. They're saying it's the way that you've implemented it, virtually identical to the way that we did it. Jogo Studios, the defendant, what they're saying is, no, you can't have a copyright over this entire genre of red versus blue.
We're talking about the biggest mistakes that could get your game taken down, and even why being legally right might still make you lose.
Well, it's Mickey Mouse, but his head's yellow, or
Yeah.
it's Pokemon, but he's got, rounded ears and, an extra digit on his hand. Even if you're right, you still lose because they have an army of lawyers and millions of dollars. Just stay away.
This is the episode every UGC creator, game dev, and even brands need to hear. We're covering gaming law, creator rights, big lawsuits, parody myths, and how to protect your name, your game, and your future. Stick around till the end because Adam drops advice that could literally save your business. Let's go.
This is Creative Juice.
Adam, how you doing?
Pretty good. How about yourself?
I'm doing very well. Thank you so much for coming on. I'm super excited to have you.
Well, thanks for having me. This is fun.
Yeah, for sure. We have lots of cool questions. I even polled the community on some questions on today's episode, so it's going to be really fun. All right, let's just jump in. So, before we get into the big topics, let's start with your background so people kind of know where you're coming from. Like, what kind of work do you do in law or gaming law?
Yeah, so I should start by saying I am a real lawyer. Sometimes people ask me that. I graduated from UCLA Law School almost 20 years ago, which is kind of hard to believe. And I practiced in San Francisco for the first 7 years. And then I moved up to Portland, Oregon about 15 years ago. And I've been practicing in Oregon ever since. My practice, I'm licensed in Washington, Oregon, and California. But I practice nationally all over the country. I have clients all over the country, particularly post-COVID. It's really common to work with people all around the country. So I started off doing commercial litigation, business litigation. That's basically people fighting about stuff, business disputes, and with kind of a focus started off with a focus on technology disputes, working with a lot of startups. And since we're in Portland, there's a lot of shoe litigation because we've got Adidas is out here and Nike is out here.
Yep.
Yeah, so we're one of the only firms in Portland, one of the bigger firms that's adverse to Nike. So we sue Nike constantly. Yeah. So when an athlete has a dispute with Nike, they often come to our firm. So for example, a big one we had recently was we represented Odell Beckham Jr., the NFL player. He actually went to trial against Nike. It was a dispute over a shoe endorsement contract. We prevailed. So I should say we defensed Nike's claim. So we were really excited about that. He actually flew us out to Las Vegas on a private jet afterwards. He was so happy, which was
my God.
Yeah, pretty cool. Partying in Las Vegas with OBJ.
Oh my God, that's the coolest story ever.
Yeah. So about 10 years ago, the way I got into all this video game stuff was about 10 years ago, were brought in to assist with one of the owners of Grand Theft Auto. There was a big fight between the three owners of Grand Theft Auto, and my firm was brought in to represent one of the owners. And that was my first foray into video game work. And after that, I started to get referrals, mostly for smaller things and a bunch of Roblox stuff. And so people would call me typically it was like a copyright dispute. Somebody would be sued for copyright. And what I realized is after I helped resolve that dispute that they actually had all sorts of other problems and legal risks that were way more risky and worse than whatever that copyright dispute was that I just resolved.
Yeah.
And so, I would fix the one issue and then I would start working on the other issue. And I really liked working in the space. Like, it's really exciting. There's like a lot of really nuanced issues and I really like the clients. I was telling somebody, sometimes if I'm working with a real estate developer, the client is like in his 60s or 70s.
Yeah. He's
been in a ton of litigation and he really uses a lawyer as a tool. He doesn't care what I think. He's just like, go do this, go do that.
Yeah.
He doesn't really care about my opinion. But what's really nice about working with younger people who haven't worked with lawyers so much is that you're really doing a lot more kind of counseling and advice and strategic stuff that they haven't really thought of before or don't know about. So anyway, so I started doing this Roblox work and they started referring me to their friends. And all of a sudden I was doing a lot of Roblox work. And I was at RDC, the Roblox convention. And I was with my clients and I was like, I really like working with you guys. I really like the UGC space. How do I get more clients? Like, I really want to do more of this. Yeah. And they were like, oh, Adam, you got to get on Twitter. You got to get on Twitter. And I was like, really? Okay, well, because, lawyers are inherently fairly conservative, buttoned down folks.
Yeah.
Never, obviously I had a Twitter account, but I'd never participated in, social media before. And so I was like, all right, I'm just going to go for it. And so I started posting on Twitter and on LinkedIn and on other places. And my posts were basically, my target audience is, young people in their early 20s in the UGC space. So Minecraft, Roblox, Fortnite, who, they've had some success. They're interested in legal issues, but they don't really know a lot about it. So I try to kind of raise things I think they would be interested in. So sometimes it's lawsuits relating to the UGC space, or other times it's just like, hey, this is a question I get a lot and people are interested in that.
Yeah.
And then from that, I've just been flooded with calls, and the more work I do, the more referrals I get. And it's been really exciting because, to answer your question, even probably more than you wanted to know.
This is great.
So what I've learned through all of this is that you've got big law firms, they've got 1,000 lawyers. They're charging $2,000 an hour. They're servicing the platform. Epic, Roblox, AAA studios, they all have these big expensive lawyers and they're super lawyered up. But then you have independent studios in the UGC space who have no lawyers, have no access to lawyers. And a lot of them are making a lot of money and are being really successful. And they're just completely almost locked out of the legal space.
Mm-hmm.
And so one of the things I have done is kind of help these people. What they don't realize is the amount of money that these clients are making. Some of them, they're making more money than our established businesses that we represent, but they don't have any of the legal infrastructure that these other companies do. And so one of the things we're doing is trying to help them, get set up with the basics and get protections. And then for some of my other clients, it's like, okay, you're making, $1 million a month. Okay.
Yeah.
What are you doing with your money? Because, do you have it all invested in crypto, or do you have a savings plan? Because for some of these people, what I tell people is my developer clients are kind of like professional athletes. They're super talented and sophisticated in one very narrow area, but they don't have some of the life skills and life experiences that you need, in long-term thinking, because you may be making $10 million a year now, but platforms change, your connection to the zeitgeist changes. And if you are responsible with your money, you may never have to work again for the rest of your life. And so, some of the things I've done is I've hooked up clients with money managers, trying to help them, all right, maybe buy one Lamborghini, but put the rest in bonds, get a retirement plan. So, that's been kind of also a fun aspect of what I've been doing.
Very cool. So not even just on the legal side, but helping them on their finances. Totally. They need help with the legal side for sure. And on the finance side, like you said, there's so many young people coming into this space. I've even tried to help some of them. People just what are you doing with the money? Some of these kids don't even save for taxes. They don't even think about those things.
It really is like professional athletes, which is there are so many sharks and they see blood in the water. And that could be, through risky investments, through stealing IP, that it's hard to know when you're young and you're making all this money, who to trust.
Yeah.
And, obviously they're paying me, but I'm a fiduciary, and my only stake in all of this, I'm not getting paid a commission, is I want to make sure that they're safe and that they're protected, and I want what's best for them. So hopefully people trust me to steer them in the right direction.
Very cool. And again, I found you on social media. So like you posting to social media is kind of how I found you. And no one that I know is doing the UGC lawyer like content stuff. And honestly, I didn't even know there's like a sub category of that in law, which now I do. For the last few years, I've been really into this space, but like it is huge. And obviously the growth of UGC over the past 5 years too has just been insane, right? So and it's just going to get even bigger, right? I think
there's a handful of lawyers kind of spread out through the country who have really kind of see the need, see the opportunity, are interested in it, and are focusing on it. But for the most part, there's a lot of snobbery against UGC. Yeah. Who people, even amongst lawyers, people like, oh, Fortnite Creative or Roblox, whatever. Like that's just a bunch of kids. Like they're like, I work for such and such studio, and it's like so much more prestigious, even though they probably don't realize that my clients are making like way more money than them.
Not a lot of people understand that. No, very cool. Great answer, man. Again, so happy to have you. So like, I got to ask this one. So you already kind of gave us the Odell Beckham story, which is crazy, but like, I wanted to know like, what's the weirdest or wildest case you've seen in the UGC space?
Grand Theft Auto dispute was probably the wildest one that I've been involved in. I can't talk about that. If you Google it, there's lots of stories about it on the internet, but I can't really get into any specifics.
Dang it. Okay, then. All right. We can keep it there. Well, another case that's currently going on right now that's it's definitely been making our rounds in the community, and I'd love to hear kind of you break it down. So, can you explain our red versus blue lawsuit between Jogo and it's not what's the company suing them?
Games.
Games. Thank you. I would love to kind of get a breakdown of that and kind of like maybe what lessons can UGC creators take from it.
So this is an interesting case because it's gone a lot further than a lot of other UGC disputes. So before I talk about this case, let's just back up and talk about lawsuits in general.
Okay.
Lawsuits are extraordinarily expensive. And so most things get resolved either before a lawsuit is filed or very early on, because oftentimes the cost of the lawsuit and the risk involved is so high compared to the reward. Yeah. So for a UGC dispute to actually go in front of a judge, for big filings to be issued, for opinions to be issued, there has to be a lot of money at stake, or else it just doesn't pencil out. So the Jogo Studios Games dispute, basically here's what's going on. Games has a game called Crazy Red versus Blue. Jogo Studios has Super Red versus Blue. Games sued them for copyright infringement and said, hey, your Red versus Blue game infringes our copyright on our Red versus Blue game. Now, in general, concepts are not copyrightable. So you can't copyright the concept of red versus blue. And what Games is trying to argue, they're saying it's not just that it's red versus blue. They're saying it's the way that you've implemented it. Like where you put items, the way it looks on the screen, the gameplay, all of that is like virtually identical to the way that we did it. That's what Jogo is saying. Now, Games is saying, oh no, this is just a concept.
Games is saying that. Jogo is saying this is just a concept, right?
Well, Games is not talking about the concept, okay?
Okay.
Games is the plaintiff, and they're saying, no, we're not going after the entire concept of red versus blue. Okay. They can't say that because they know that that's an argument that will not fly. Instead, what they're saying is your red versus blue is virtually identical to our red versus blue. All the unique and creative choices you could have made, you copied the way we did it. Okay. Jogo Studios, the defendant, they're trying to characterize it the opposite way. What they're saying is, no, you can't have a copyright over this entire genre of red versus blue. That's what you're actually trying to do. Everybody does this. There's nothing special about this. And you're just trying to get a monopoly on the entire space. In addition, what the defendant, Jogo Studios, is saying is there's nothing even creative about this. You're just using Epic's like pre-made assets and kind of arranging them in ways, and you don't have a right to do that. So Games not only filed a lawsuit, they also are seeking a preliminary injunction. That's when they ran to court and they said, Judge, we are so confident that we're going to win, and the harm to us is so bad, you need to immediately take the infringing game down. Take Jogo Studios' game down. It's an extraordinary remedy that's rarely granted. And I think, as a armchair lawyer quarterback here, a very poor strategic decision by Games' lawyers to do that. Okay. So the judge issued a tentative ruling last week. A tentative ruling is where the judge says, here's where I think I'm going with this. Show up at the argument. You can try to talk me out of it if I got anything wrong. The judge, in his tentative ruling, ruled against Games and for Jogo Studios. Now, his reasoning is really interesting. He didn't rule on the merits of the copyright dispute. He didn't say, that there is copyright infringement or there's not. He ruled based on some other issues. Number one, he said, what's the emergency here? These games have been on the platform for a year plus before you filed this lawsuit and before you sought this emergency injunction. If this was truly emergency, you would have done this a year ago. You can't come in now and say it's an emergency when you sat on your hands for a year. Okay. Number two, he said, it's not even clear to me what you own and you're claiming a copyright for, because all of this is subject to Epic's terms of service. And Epic's terms of service basically gives it the right to use any IP that you create as a UGC creator on its platform. So the judge said, hypothetically, I could grant your preliminary injunction and say, Epic, you need to take this game down. But Epic wouldn't have to comply with that because its own rules say that they have the right to keep it up. So what's the point of me even granting this if Epic has the right to keep it up in the first place? And then he said, by the way, why isn't Epic a party to this? Shouldn't Epic be a party to this lawsuit? Because I think there's this concept of a necessary party under the law. You can't, you have to include all the entities that are involved in the dispute. And Epic wasn't named. So he says, I want further briefing from Epic about what their position is on all of this.
I'm learning so much right now.
The plot thickens. Now, what do we know about Epic's position right now? Here's what we know. Games submitted a DMCA takedown notice to Epic about Jogo Studios games. Epic didn't process it. They didn't take the game down. Why not? Well, obviously Epic didn't want the game to go down. It could be for a number of reasons. One reason is that they didn't think it infringes. A second reason would be the implication of this. If Epic took this game down, what does that say to other creators about what the concept of infringement means? And there's potentially thousands of other games that could all be impacted by this.
Definitely.
And the more games that come down, that hurts Epic's bottom line, right?
Yeah.
Because Epic is incentivized to have as many of these games up and successful as possible. And people aren't going to make Fortnite Creative games if they think that they can just be DMCA'd for anything, right? The other thing that we know is that Epic submitted evidence in favor of Jogo Studios in connection with that preliminary injunction lawsuit. Now, they didn't say, this is our position, but what they did do is provide a declaration explaining that, number one, there are thousands of games on Fortnite Creative that are red versus blue.
Yes.
And number two, they discussed their rights under the terms of service. So Epic didn't say, this is our position, but they didn't submit a declaration on behalf of Games. They submitted it on behalf of Jogo. And the judge actually said that. He said, well, I don't know what Epic's position is, but it does seem interesting that they submitted the declaration on behalf of Jogo and not on Games. So in any event, to make a long story even longer, there will be another hearing where the judge is going to get information about what Epic's position is. But it seems very, very unlikely that Games is going to get this injunction. So this is enormously significant for a bunch of reasons. Okay, number one, when I say this stuff is expensive, The cost of an injunction like this could easily be $1 million in legal fees on each side. Number two, when a judge denies an injunction, even though he says, I'm not ruling on the merits, he's basically telegraphing to the parties what he thinks of your case. And so if you lose an injunction, the rest of your dispute's going to be a real uphill battle. On the other hand, if you win an injunction, you've basically won the whole case because the judge is saying, this is what I think about it. So typically after an injunction hearing, the parties settle because it just doesn't make sense to spend more money fighting when the judge has already strongly telegraphed what his position is on all of this.
Yeah.
Yeah. And number two, the denial of this is going to have significant impacts on other creators in the space in terms of setting what are the guardrails of what we can do and what we can't do.
No. Yeah. Wow. I'm learning so much. We're going to have I have more questions here that probably going to dive more into some of this stuff that you'll answer. So this lawsuit, we don't even have to use this as an example, but any lawsuit. So say they take me to court, right? And this happens to me and I'll have these $1 million legal fees now. Am I on the hook for this? Can I make the person that's taking me to court pay this? Like, how does that work?
Yeah, so that's a great question. In the legal system in America, in general, you're responsible for your own legal fees, whether you win or whether you lose. There are times when there's like a statute or like a rule of law that says the losing party has to pay the winning party. And then also in agreements, people can contract to say, hey, if we get into a dispute and we have a lawsuit, the loser pays the winner's fees. But unless there's some special thing like that, everyone pays their own way. And in copyright disputes, which is what this is, generally everyone has to pay their own way.
Ooh,
exactly.
That's rough.
And so if you get sued for copyright infringement, one of the things you consider is win or lose, is it worth paying my attorneys, $1 million, or would I be better off using that money, a fraction of that money, to try to settle the case?
Yeah, which of course you are. If I'm on the hook, that any business, any normal person would understand that. That's wild. Yeah, I didn't know that, and that I always thought, I guess in my mind, that if I was sued, I won, they could pay my legal fees still. You know what I mean? That's like that seems normal, or that seems like that's how it should be done.
I know that's how they do it in other countries. That's not the way they do it in America. In America, it's a very low bar to file a lawsuit. Anybody can do it.
Isn't it $20 or $30 or something?
I mean, it's a few $100.
Yeah, a few $100. Yeah.
But legally, it's a low bar. It's not hard to file a lawsuit that passes muster, but it is very hard to win.
Yeah. Wow. No, that's great. Oh, man, we're starting off with a bang. That's wild. So I've kind of covered some of this, but I want to get into it. So like one of the biggest issues I think creators run into is IP and copyrights, right? We talked a little bit about that. So like, what is the real risk of using IP you don't own?
I get this question constantly.
I bet.
Yeah. Here's the deal. Nobody really knows when something, people ask me all the time, if I change my asset so it's 30% different, is that enough? Can it be 20% different? Can it be 40% different? And the answer is, it depends on what you're stealing, okay? If it's Mickey Mouse, if it's Nintendo, those are notorious litigious companies who are very protective of their IP.
Yeah.
And so if you're like, well, it's Mickey Mouse, but his head's yellow, or it's Pokemon, but he's got, rounded ears and, an extra digit on his hand. Nintendo doesn't care.
Yeah.
And even if you're right, you still lose, because if Nintendo DMCA's you, you're not going to fight it because they have an army of lawyers and millions of dollars, and most creators don't. So what I tell to people is, you have to really consider, and this is not legal advice, right? But you have to consider, who are you stealing from? What are their assets? How much money do they have? How big are they? And what is the likelihood that they're actually going to go after you? So Nintendo, Marvel, Disney, stay away. You got to give them wide berth. Yeah. But if it's some other independent creator or small company, or who's much less likely to either notice or go after you, probably the margin of error is larger. So if it's some random thing, it's like, well, you might be able to get away with changing the color or changing changing the eyes or whatever it is. But like, if it's one of those big people who's litigious, just stay away.
Stay away.
Right? Because even if you're legally in the right, the second once the dispute starts, you lose. So that's the answer.
No, great answer. And to kind of piggyback on that, like, so what if this is kind of more around parody law, right? So like, what if I called my version of Eggman Egghead and use a custom model? Would I be protected under parody law or something like that?
Yeah. So
Sega is coming after me. Yeah.
Parody law is massively misunderstood.
Okay.
What you're describing is a common misconception. That's not actually parody. So there's this thing called fair use, all right?
Okay.
Which many people have heard, but most people who aren't lawyers don't understand. And fair use is a defense to copyright infringement. It only comes up after you're sued, and you get to say, here's why what I did was actually okay. Again, once you're in fair use territory, you've already lost because you're in a dispute. But one of the factors for fair use is this a parody? What you're describing is what's called like satire. A parody under the law is where you are actually using the same asset or images or IP, but you're doing it in a way to critique or
like
make some
South
type
Park's using Trump's head.
Exactly.
Right?
That's actually the image that I was going to use. That's the example I was going to use. Okay.
Yeah.
So the reason why what South Park does is parody is what they do is they take the actual copyrighted image, like, making fun of Tom Cruise or Kristi Noem or Trump, right? The protected IP, but they're using it to make some type of critique or commentary about Scientology and Tom Cruise or, ICE arrest and Kristi Noem. An example of something that somebody tried to say was a parody and lost in court. Somebody made a book that was a mashup of Dr. Seuss and Star Trek. And it was like, instead of, the places you will go, it was like Star Trek stuff, but like using the same type of like poetry. They were sued by Dr. Seuss and they lost. And what the court said is, that's not parody. That's just humor in the same style as Dr. Seuss. That's not fair use. So that's kind of the difference. It's a subtle difference. So the answer to your question is what you described is not parody. It's not parody. But if you just look at it from a straight IP analysis, is what I'm calling this thing different enough from what it is that it's not likely to create confusion? Maybe you're okay.
Okay, no, great answer. So this is kind of something that was just recently happened, and it's around Squid Games. So Squid Games, they've had these knockoff Squid Games in Fortnite. I'm sure there's on Roblox everywhere.
Oh yeah, I've worked on them.
There you go. So this game's been up for a year, maybe longer, doing numbers, right? It's a top game, Octo Games, whatever that's called, and stayed up there. And then finally they announced Squid Games IP is going to be coming into UEFN. Basically, they started taking down some of the games. But the thing was, like, literally the next day there was a brand new one up, and it would stay, and it was still crossing that line. I guess I don't know what to ask on this question, but like,
how does that work? Why is that happening?
How does what's going on there?
Yeah. Okay. Brands now are really struggling with UGC because what they're seeing is, particularly on Roblox, but also a bit on Fortnite, what they're seeing are essentially pirated games that are massively successful. On Roblox, the classic example was My Hero Academia. And also there's this with Squid Games where you have knockoff unlicensed versions that are massively successful. From the brand's perspective, brands don't like when their IP is being used without permission. On the other hand, this is great publicity.
Free press.
Yeah, exactly. Because you have all these kids who are playing, Squid Games on Roblox and on Fortnite who might not otherwise get onto Netflix and even know what it is, right? So Netflix or whoever the IP holder has a choice. Are we going to DMCA this game and take it down and make our own game and put it up, right? Or just take it down. So a couple of years ago on Roblox, there was a very successful game that was based on My Hero Academia, and the Japanese anime company that owned it DMCA'd it, so the game got taken down. This was a beloved game, and they put up their own official game. And everybody hated the official game. And so they completely alienated their target audience because now everybody hates the owner of the IP for like ruining their favorite game
Yeah.
and putting up their own corporate crappy game that nobody wants to play.
Mm.
And so IP holders are struggling with, what do we do in this situation? What they should be doing is they should be reaching out to these unlicensed games and partnering with them and, working out a reasonable royalty. And so it becomes a win-win for everybody. The only reason why that's not happening more is, I think, a lack of a few reasons, but I think one is a lack of connections between the developers and the IP holders. A lot of these developers are 17, 18, 19 years old.
Yeah.
And, the IP holder is, some 45-year-old white guy in a corporate suit somewhere.
Yeah.
Right. And they don't know each other. They're not connected. And if they do connect, there's a massive culture shock, right? Because, because brands want to have fully developed, products to reflect their brand. And that's just not how we do it in UGC, right? So like on Roblox in particular, Fortnite 2, when the games get put out, they're often half baked because people want to see like, well, how does this go? Yeah. And then they get input from their communities and they improve the game over time. They take the bugs out and they become fully baked. And brands aren't comfortable with like having half-baked stuff out there. Yeah. And the other thing I see is they're also not used to the speed. So like every once in a while, I'll see a contract between a brand and a developer. And the brand says, well, before you can, make any updates with our IP, our characters or whatnot, we have to have approval and we need 14 business days before we approve. I'm like, 14 business days? The whole genre is going to be gone by that time, right?
The game would be done in those 14
exactly.
days. Yeah,
exactly. And so, I think brands are starting to get a little bit more wise, but it's just not how they're used to doing things. And I think they're still getting used to this new reality.
Yeah.
But I didn't exactly address your question.
Oh,
and your question was, how is it that a pirated game can be up, it gets DMCA'd, and then the next day there's another one, and that one stays up? And the answer is that that's the law and that's the system, which is the onus is on the brand to submit DMCA notices and not on the platforms. The platform, the incentive for the platform is to do nothing because the more stuff that's up there, the better for them. And they're not liable. Platforms aren't liable for UGC. Yeah. That's the law. They're not responsible for the stuff that their users create. And so they're kind of like, hey, it's not our fault. Like, if you want it down, send us a DMCA. And so, companies often, what they do is they hire other companies to just submit DMCAs over and over and over again. But if they're not doing that, games they're going to just keep proliferating.
Yeah, and I always assume just like why would Squid Games until now that they're making their own IP in the game, it's free press. Like they're just going to keep it up there. And sure, that game could be making a few $1 million here and there, but to them that's not even worth the legal fees sometimes. Whatever it is sometimes. So very good answer. And I was actually just going to ask you this is about like the discovery page on Fortnite and around like, are they legally responsible for promoting stolen content, right? And you kind of answered it a little bit, but
so this is like a very kind of topical and hot issue in the law. So platforms have immunity for the stuff that their users put on it, okay? Unless the platform is doing something to actively promote it.
Okay.
There are cases about algorithms. Do algorithms constitute active promotion? So far, the court cases have said in interest. In those specific instances, no. It was not enough. It was not a strong enough hand by the platform to make the platform liable.
Yeah.
So those automated algorithms, at least for now, are okay. There probably will be a case someday where some platform is held to have had too strong of a hand in making decisions about what to promote and what to not to promote. Yeah. But so far, the law seems to be that if you have some type of neutral algorithm, then the platform is not responsible. Now, what's a neutral algorithm? I mean, that's a whole other thing. Yeah.
No, that's crazy. So I mean, you kind of just I just thought of this, and I don't even know if this is true, but it kind of makes some sense. So Epic early on, probably before UEFN came out, they would add like they would do different contests or do different promotional things for some of the top games and like give you special XP or items you could unlock if you went and played a creative game. They were just trying to push people to try out creative, right? It was great for everyone. It was cool, but they kind of stopped doing all of that. And I'm wondering if, and maybe not, but maybe there is some legal things around that where, because they're technically promoting those games, right?
Yeah, it certainly looks like encouragement.
Yeah, exactly. So, and then there's the other side too of like Epic picks. So there's a curated row that Epic will choose every week. So a few maps that get to play up there. So I'm wondering, and it's long queue times to get in there as well. But there's probably a lot of it might be legal queue times, right? Because I guess they had to really think about that.
Yeah, I'm imagining they're not picking games that have Mickey Mouse in them, right?
Oh no. And I will say this, they're definitely been cracking down a lot more, and they're really pushing more of the innovative games and things that you really haven't seen before. I will say sometimes you'll see a red versus blue in there. So, however that none of us really know how it's all done and picked. But anyway, it's just we're all on the outside blaming Epic for everything or saying this or that, and a lot of times there's other reasons or factors, which this is any business, anything that goes into it, but like there's other reasons why we just may never know. But anyway, and again, this is just me speculating. I don't know anything, but very, very interesting.
Yeah, it's all really super interesting issues. And the other thing that can't be underestimated with platforms is, on the one hand, being huge is their giant lawsuit targets, and they get sued all the time. All the time. I mean, I get contacted constantly to ask if I'll be a lawyer for like a lawsuit, an addiction lawsuit against Epic or Roblox, which, by the way, I don't take those. Yeah.
That means they've lost some of them. I mean, I think Epic's had to pay big money.
No. So the video game addiction lawsuits. Well, let's just step back for a second. Let's talk about video game addiction lawsuits.
Yeah.
Plaintiffs' lawyers have been trying to steal the playbook that they used for tobacco litigation. So, 20 years ago, there were lawsuits all around the country against tobacco companies, basically saying your products were addictive and they've made us sick and you're responsible for that. So plaintiffs' lawyers have basically tried to take the same tasks and apply that to video games and say, you are intentionally making your video games addictive so that people keep playing them.
Yeah.
So far, there have been 1 or 2 cases that I know of where the courts have kicked those lawsuits out and said, no, those lawsuits have no merit.
Yeah.
You lose. And so the platforms have won. Those lawsuits are still they're still kind of being filed all around the country, but more and more people are going to point to those first 2 ones where they've lost and say, hey, they lost in Illinois. They should lose in California too.
Yeah.
And so it'll probably take 1 or 2 more bad rulings for the plaintiffs, pro platform, before those lawsuits go away.
Okay, interesting. And sorry, let me correct myself. What it was around the item shop, and I don't know if it was around buttons or how it was set up, but there was something about like people. It made it easier for people to buy something. There was some lawsuit around that.
Oh, and
I think they lost.
Yeah,
Epic lost, had to pay money for that. So pay back money on that.
Yeah, that's different. What I've been working on with some of my clients now is there's a lot of loot box disputes. Obviously you all know what a loot box is, right?
For sure. I mean, we can't really do that. Just kind of, but it's, yeah. So definitely Roblox though. Yeah.
So, what video game lawyers say is a loot box is kind of like buying a pack of baseball cards. It's $2 and you have 10 cards and you hope that you get something good. Whereas a plaintiff's lawyers try to say, no, it's more like gambling.
Yeah.
Right. And there are certain things that you need to do on your loot boxes to at least insulate yourself from these gambling claims, like putting the odds and putting the cost of the goods on the same screen as the loot box. Yeah.
Interesting. That's good to know. Because look, Call of Duty, I've spent thousands of dollars on loot boxes. They got me, and it did feel like gambling.
Yeah. Well, I mean, my clients are the game developers, so my position.
And I'm not even for sure. I'm same, right? I'm playing devil's advocate here.
Yeah.
And again, maybe they're I wonder what their algorithm or whatever their odds were on there on Call of Duty. They made it fix it, but
They didn't show it. They didn't show it when you were playing.
I don't know if they. I don't think they did. This was Black Ops 3. I even made a video, and I've spent stupid money on some of those things, but I wanted to get everything.
Hey, you should contact a plaintiff's lawyer. Maybe it's not too late.
Yeah, no kidding. I got video, so I got proof. Nah, look, I'm an adult. I know what I was getting into.
Yeah,
but yeah, no, that's fascinating. Thank you, Adam. So you did kind of just mention like what's big brands decide to take legal action. What's the reality, right?
Yeah. So these big platforms, they've got a lot of money. Lawyers call that a deep pocket, right? Because when you win a lawsuit, if the party doesn't have money to pay, then what's the point? Okay.
Yeah.
So these are deep pockets. They've got the money to pay. The downside is that if you sue them, they have an army of lawyers and they're not going to settle because they don't want to set a precedent that they're an easy target. And so, if you are going to bring a suit against them, you really have to be in it for the long haul, and you have to have sufficient support in order to make it go.
So, piggybacking on that, let's just say, for instance, we talked about Nintendo and Disney. What if they did sue a creator?
So, if you get sued,
what happens?
If you're a creator and you get sued by Nintendo or Disney, you have essentially two options. Okay. Now, assuming you're guilty of what they said that you've done, you go to them with your lawyer and you say, I made a mistake. We're sorry. Like, here's how much money we made. I don't have a pot to piss in. If you win, I'm going to declare bankruptcy and you're not going to get anything anyways. I'm sorry. I won't do it again. Can we please settle? Please don't ruin me. And, most big companies, they're, ultimately they're making a business decision. Right. And so if they can say, okay, the guy's learned his lesson, we're going to get a little bit of money, make him feel some pain, we'll settle and move on. They're not going to spend 3 years litigating against you to collect nothing. Right.
Yeah.
If you're not guilty of what's alleged, you're in a rough spot because you probably don't have enough money to defend the lawsuit.
Yeah.
So the alternative is to go to the lawyers, explain to them why what you did was okay, and hope that you can come. They know obviously that you don't have the juice to like make it all the way, but hope that you can present a package that's kind of a win-win for everybody. We didn't do anything wrong, but how about we do it like this in the future, or we'll make these tweaks. Would this work for you? Everybody can go on and try to make it a win-win.
Okay. No, that great answer. Yeah. I kind of wanted to know that as well. Like, what's that process? What's that look like? But, very good point. I mean, very little people can defend themselves against those big companies. And look, I used to work for BP Exploration. Same thing. There was lawsuits going on with BP because they changed retirement fund for certain people, and they got way less than they more. Anyway, they actually lost the case eventually. But what they did is they pulled. By the time it was all done and settled and all that, most of the people were dead. Like, they couldn't even get their money. You know what I mean? And that's just that's what they do. And the point of you saying it's more or less they don't want to set a precedent too. So it is worth for them to fight and spend whatever it is. But anyway, it's just it's everywhere.
Yeah. Well, when people complain to me about the legal system, I say, hey, take it up with your legislature. It is what it is. It's not my.
For sure, it's like a car mechanic. Hey, take it up with or whoever. Your car.
Exactly.
I'm here to fix it, man. I don't know.
Exactly.
So let's kind of shift things over to ownership and around actual game ideas and mechanics. This is a big question and topic. Can you protect an original gameplay mechanic or a mode in Fortnite, which we kind of just have a case that says no almost, but go ahead. Yeah.
So that's a really interesting question. And the answer is, I am not sure. So,
okay.
So if you were looking at whether you can copyright a particular mechanic or code, I would need to look first at kind of the UEFN terms of service, right? Because those are going to say what they own and what you own. And there's likely to be some amount of, it might say, hey, anything you make on here, we own anyways. It's our platform, it's our code, we own it all. It's likely to say that there's probably some line there, but the answer is I don't know off the top of my head.
No, and that's fine. I just, I think, like you said, it's just like case by case probably, and everything. And so on that line, what about my name of my game? So like red versus blue, let's not use that example. That was done before and after. It's been whatever. But like, say I make, the most advanced, I'm trying to think, 1v1. This is a bad example, but I'm just trying to think of not a proprietary name, but just like the most, I don't know.
What you're asking is about brand protection.
Yeah.
Okay. And this is something that small business owners have been dealing with for decades, whether they're opening a brick and mortar store or a website or a studio or your game. Okay.
Yeah.
Your brand is protected by trademark law. Okay. Trademark law. So the name, what you decide to name your company, whether it's, a shoe store or a video game or the name of your studio, that is governed by trademark law. Okay. Under trademark law, certain words can be trademarked. That gives you exclusive right to use it, and certain things can't. So if you use a descriptive title in general, just generally, that cannot be protected. So for example, if I have a store that sells groceries and I call it the grocery store,
yeah,
I can't trademark that and prevent other people from using the grocery store. If I have a game that's like a 1v1 shooter game and it's called 1v1 shooter, I can't get a trademark over that. Okay. But if I use a made up word like Starbucks or my coffee company, I can prevent other people from having a coffee company called Starbucks. And now my brand, Starbucks, has a special meaning that everybody associates it with. Yeah. So if you pick a fanciful name for your game, if you call it like, can't think of any good examples off my head.
I know, me either.
Creative Juice. Okay.
Yeah, there you go. Yeah.
Creative Juice. Creative Juice, doesn't describe a podcast. It doesn't even obviously describe what you're talking about.
Yeah.
But it's a unique, fanciful name that, unless it's been used before, probably you could trademark. And nobody else could have a podcast called Creative Juice. And the benefit for you is that when you go to the Apple store, if somebody else has a podcast called Creative Juice, you can get Apple to take it down. So you're the only one. Okay. Same with, so I'm going to talk about Roblox. Let me give you an example of why having a trademark is important. Let's say you come up with a popular game on Roblox called Steal a Brain Rot. Okay. What happened once that game became a hit? All sorts of people on Fortnite started creating Steal a Brain Rot style games.
Yep.
Steal a Brain Rot is considered a trademarkable name, and I actually don't know if it's trademarkable or not. The owners of Steal a Brain Rot can go to Fortnite and say, take those games down because of the name. It's not talking about the content of it. The name itself protects you. And so there's value in having a unique name that nobody else can, because everyone knows what Steal a Brain Rot is now. Everyone knows what Grow a Garden is. If those names are trademarked, you can prevent other people from using those names.
No, that's great. Great. I think now I'm thinking of it like The Pillars. This is a game that got super popular, really easy game loop, and people have since been using it and copying it. And I'm wondering, I don't know if you got it trademarked and if you could do anything, but I think.
Or same with the pit, right?
The pit. Yeah.
Exactly. If the pit can be trademarked, that means nobody else can call their game the pit.
The pit.
Yeah. And I know that was a very hot dispute for a while.
It was. What if I could I call it the pit unlimited or ultimate or no? I mean, it's just like the pit is no longer in your title anymore. No one can use it.
In general, the standard that is evaluated by is, will it cause consumers confusion about the source of it, right?
That's the reason you're using the names of people in your game. Yeah.
So that's why I can't have a company called Amazon with like 4 N's.
Yeah.
Because it creates
Google with 4
an extra O, right? Because it creates or I can't have, mine's the Google.
The Google, yeah.
Yeah. So, the reality is with the law is what you think is fair or what makes common sense is actually typically close to what the law is. And even if it's not, judges typically want to do what's fair and want to do something that's equitable. Now, sometimes their hands are tied and they can't do that. But in general, like when people come to me and they say, well, I've got this great technical argument, nobody likes technical arguments. Juries don't like it. Judges don't like it. You just look like an asshole, you know?
Okay. Well, and in the pit, though, I think that there was, it was on Minecraft maybe, or don't quote me. It was another game had the pit, like some of the ideas. So it didn't directly, I don't think, come from that game. So yeah, I'm sure, I don't know what happened with all that lawsuit or anything. I didn't follow it much, but yeah, it'd be interesting. Kind of following on this, and again, it's just kind of like, can creators copyright like verse code? Can they copyright their verse code, and then how do licenses work when collaborating or freelancing with your code? So if somebody wanted, anyway, yeah, I'll let you answer. Yeah.
So in general, software code is covered by copyright.
Okay.
If you have software code that's unique and copyrightable, and you copyright it, you can share it with somebody else under a license, where you say, I'm going to let you use this, but you have to pay me a certain amount of money for that right. That's how licenses work.
Huh? So that it is possible. Okay, that's good to know. I think that was a question from the community. So I
don't know if verse code is specifically copyrightable because I don't know what UEFN's terms of use are. But in general, software code is protected by copyright.
Yeah, I mean it is.
Let me back up for a second.
Yeah,
I think this will be helpful for your listeners.
Okay.
There are basically 4 sources of law that protect your games. The first is trademark law that protects the name of your game and the name of your studio and possibly your logos. The second is copyright law. Copyright law protects the unique expression of your games. Again, concepts aren't copyrightable, but the games are. The example that I give is you can't copyright the game of chess, okay, the way it's played, but you can make really unique figurines on the chessboard that are copyrightable. So I could have a copyrighted Simpsons chess set where Marge is the queen and Homer is the king, and those pieces can be copyrightable, but you can't copy the chess set. It's got to be unique.
I see.
The third is trade secret law. Okay. Trade secret law protects your unique, secret, valuable things. Your software code can be covered by trade secret law, but you have to protect it and keep it secret. So things that people can see, like your UI or UX, that's not covered by trade secret. It's the stuff under the hood.
Okay.
And the fourth is contract law. Those are your contracts that you have with people related to your game that you can enforce to protect your rights. So those are kind of that's the table: trademark, copyright, trade secrets, and contracts. And those are the tools that creators should use to protect their games.
Amazing. No, thank you for sharing that. That's very, very good for creators to hear. So I want to kind of talk business a little bit. So say you're selling a game or an IP, right? What are like the key things to include when selling ownership or game IP? We're starting to see that some games are starting to get acquired and things like that. And so, yeah,
I do a ton of this work.
Oh, okay.
I do a ton of buying and selling video games and interest in video games. Without getting too complicated, there are a few very important things. The first is, when and how are you going to get paid and how much, right?
Yeah.
Everyone wants to know, well, how much am I going to get paid? But what I would encourage creators to think about is, what happens if they don't pay me? Okay. How am I going to force them to pay me? And so the way you do that is through law and venue provisions in your contract. So people come to me and say, hey, I had a contract to sell my game, $50,000, and I gave him my game, but he didn't pay me. And I say, oh, okay, well, where are you located? Well, I'm in Michigan. I'm like, well, where's the buyer located? He's in Saudi Arabia. I'm like, okay, well, how the heck am I going to sue somebody in Saudi Arabia and get money from them? Yeah. Because the cost of doing that is astronomical. Or maybe they say, oh, I only know his Discord name. I don't know where he is, and you can unmask people, but it is very, very expensive and time consuming. And the amount of money at stake has to be like millions of dollars in order for it to, but there is a way to do this. And the way that I recommend is through arbitration clauses and venue provisions. So this person in Saudi Arabia, had they signed a contract that said, in the event of a dispute, there's going to be arbitration in Portland under Oregon law. Then I say, okay, great. We can commence an arbitration. If he doesn't show up, you win by default. You don't have to worry about like tracking this person down or any of that other stuff. It's cheap. It's fast. Now, there might be some collection issues, but it's at least if you get a judgment against him, you can always go to Roblox or to Fortnite and then seize them, basically garnish the money out of their accounts. So what you've done is by contract, you've created a convenient forum in order to enforce your contract. Without that, it's not
good advice. Great advice. I want to piggyback kind of on this a little different, but like, so you make a game, right? Or, and you're under contract and you make it for them, but then they just totally ghost you, right? So like you were hired to make them a game, but then they just, like I said, ghost you. Like how do you fight back? Is there anything you can do?
Yeah. So in your example, I'm the one who's making the game and they didn't pay me. Is that the deal?
Yeah. I hired you to make me a game, and whatever happened, who knows? I just stopped talking to you. I don't want anymore.
Again, it's a very similar thing, and that's the importance of the contract for the person doing the work, which is I need to know who is paying me and how am I going to collect that money if they disappear. Again, because if the person is in Lithuania and you're in California and they owe you, 10 grand, that's a lot of money to you, but it's going to be virtually impossible to ever collect.
Yeah.
But if you have an arbitration provision that says like, hey, they have to come to your backyard, that's going to give you a lot more leverage in that dispute.
Got it. And that's just important too. I think a lot of these people are so new, they don't understand. Like like you need to get in these contracts. You got to call Adam.
The other thing that I encourage people to think about when they're buying and selling video games is people come to me and say, oh, well, I've got 20% equity in this game. Legally, there's no such thing as equity in a game. Okay, that's not a thing. What I try to get people to think about they're actually common sense questions, which is what revenue share are you going to get from the game? Okay. Is it 20%? If it is, say, I get 20% revenue share. You don't have to use fancy legal language. Plain language is actually the best. 2, who gets to make the decisions about the game, right? When you have 20% equity in the game, that doesn't say, well, what if you and the other guy, he wants to, add loot boxes and you don't? Well, who gets to decide, right? Mm-hmm. So put in your contract, like who gets to make the decisions or what happens if we have a dispute? This sounds funny, but sometimes when you have a 2-person company, I'll put into the contract in event of a dispute, they flip a coin, right? And because it's a fast, cheap way to resolve a dispute,
Plus, then you're just getting away from your team essentially from getting into a dispute. You solve it with a flip. That's smart.
Exactly. So what revenue do you get? Who gets to get? Who gets to make the decisions, and also IP, who owns the IP and what do you get to do with it? So if the IP is co-owned, you got to think about, well, what happens if I make a sequel on my own? Who gets the revenue from that? Do we split it the same amount? Like what happens, for example, if I've got, let's just use Red versus Blue, right?
Yeah.
I co-own Red versus Blue, and I decide to make Red versus Blue 2. It's a new game. Everyone goes over to Red versus Blue 2, and I say to the other guy, like, hey, this is my game, not yours. Mm-hmm. Right? Now, there is copyright law that covers that, but what would be better is an agreement of like, hey, let's agree that neither of us are going to make any sequels unless we both agree to it. That way, we're not reducing the viability of our original game. And if we do make a sequel, let's agree in advance of who gets what revenue from it, right?
Yep.
And then the other thing that comes up a lot is people do revenue share agreements in exchange for work, right? So I co-own a game and I'm going to be in charge of marketing and the other guy's going to be in charge of development and we're going to split it 50-50. And guess what? The game is blown up. It's making $1 million a month. And this is going on for 6 months. And now I don't feel like marketing it so much.
Yeah.
Right. And so now I'm not marketing it, but I'm still collecting my 50%. And the other guy's like, well, what the heck, man? Part of your 50% is that you have to do the marketing work. Yeah. But there's nothing in any agreement that says how much marketing work I have to do. Do I have to do 40 hours a week? Do I have to do 5 hours a week? It's just like, well, I'm doing marketing. Right.
Yeah.
And so more of that you can address up front, the better.
Makes sense. No, makes sense. But yeah, no one thinks of that. You never get to that point until it's too late.
Yeah. The other thing too is if I'm getting paid in a revenue share, so I get 10% in exchange for doing development work. Well, what happens if I get fired or I quit? Do I continue to get that 10% forever? It's almost never addressed in the contracts. The developer always thinks that he gets it forever, and the game owner always thinks he only gets it for as long as he's actually doing work. And so you need to specify that in the contract of like, well, what happens if I quit? Or even worse, let's say the game is not released and I'm coding it and for 10%, it gets released and a month later I get fired, right?
Yeah.
Well, and they say, well, sorry, you're not working on it anymore. But you're like, well, I did 6 months of unpaid work in expectation that I was going to get this 10% forever. So you should say that in your contract. What happens if I get fired? Maybe if I get fired, I'm getting 10% forever, unless I get fired within 6 months, in which case it goes to nothing. Or if I work for 8 months, and then get fired, then I get a tail of, 5 or 6 months of, or whatever. It can be done however you want it. But the important thing is that if it's written down, it makes it a lot easier for a lawyer to come in later and help you enforce your rights.
Yeah, no, great points, man. People should be taking notes. So we talked about a little bit like cross country. Sometimes like litigation can be very, very hard. I kind of want to talk about NDAs and contracts that are across international borders. Can you enforce them, NDAs, if you're freelance? Like, how does that work?
So contracts can be enforced internationally, but it's, again, what is the enforcement mechanism, and where is the venue going to be? So if I have an NDA with somebody and they violate it, what are my remedies and what are my rights, and where am I going to go? So it's really important that you specify in your contract where we're going, especially internationally, where are we going to resolve this? Because what you don't want to do is have a fight where, the person you're in Montana and they're in Spain, and you file suit against them in Montana, and then they say, no, you're supposed to bring the suit in Spain, and they file a lawsuit in Spain, and now you're just wasting money on attorney's fees, and you're not actually even talking about, you're arguing that process and you're not even talking about the underlying thing. So you try to want to get all that process stuff cleared up in advance with agreements. Now, here's the thing with NDAs in general. Let's even say you've got two people in California, there's an NDA, and somebody violates it. And somebody comes to me and says, hey, I signed an NDA and this guy violated it. And my first question is going to be, well, so what?
Yeah.
Okay. Why did it harm you? Right? What did he do? Now, if I'm Coke and I have an NDA with somebody and they released the Coke formula onto the internet, that's a big freaking deal. Okay.
Oh, yeah.
There's a lot of harm. But if it's just some random stuff that doesn't really have any value anyways, I'm going to say, well, who cares? And part of it is, in general, you have to prove damages. Okay. And so if there's no harm, the court's going to be the same way. They're going to say, well, who cares? Like, why are you here? It's going to cost a lot of money to enforce your rights. So there better be some legitimate violation that matters. Yeah. But if there's stuff you can do about it.
Yeah. And I think for UGC or for this platform, for instance, like I had a game idea, you know what I mean, or whatever, or I have the game kind of half baked. It's the MVP, and I want players to come test it, right? Say that, and I have them sign an NDA because this game, whatever, this is going to be the next big game. Well, then they sign it, and maybe they go and take my idea, make the game, and it takes off. You know what I mean? Is there something there?
Yeah, absolutely.
Okay.
I mean, that what you're describing is what NDAs are for, which is, I've got a special idea that I want to share with somebody, and I don't want them to copy it because I have a market advantage by being first, right? So after your game is released, other people can make similar concepts and do similar things because that information is out there in the world. But it wouldn't be fair for you to show that to them and say, look at my great idea. And then they go home and they spend the next 48 hours trying to get out first. Yeah. That's a legitimate harm. And that's an NDA can be enforced. But again, where is it going to be enforced? Do you know who the person is who signed it? Yeah. Is it their real name? And also,
are they 18?
We haven't even talked about that. Are they 18? If they're minors, contracts with minors are not enforceable. You need to have a parent sign on their behalf.
Yeah. That's a good point. Yeah. So that happens, I'm sure.
Yeah. Oh, I see it all the time.
Wild. no, this is seriously, this is such great information. We have a few more questions left. We're cooking. And again, thank you, Adam. So this one is another question from the community. It's definitely a little relevant for the Fortnite creators in the UGC space, but like, what should creators do if like Fortnite updates break their game and it causes them income loss? This happens. I mean, probably every update almost, right? Like
here's what they should do. They should fix the game as fast as possible.
You're right. And most do. But yeah, I'm sure there's probably something under law and you have to probably go through Epic's terms of service or something there.
Platforms they're your moneymaker. You don't want to bite the hand that feeds you.
Yeah.
Because even if you're right, first of all, it's going to be enormously expensive to prosecute it. And second, they have so many ways that they can retaliate against you that you don't even know about and that you'll never be able to address. For example, let's say you get into a tiff with Epic about, who knows what. And guess what? All of a sudden your game is not being promoted in Discovery.
Yeah.
Now you're screwed.
Yeah.
Right. I mean, or you're never on picks you're never on picks, or you're not picked for awards or whatever it is. Like, they have so many ways that they can harm your business. The MCAs against you are processed immediately, regardless of how strong they say. So it's never worth going after the platform if you're a creator. It's super important as a creator to, especially as you become more successful, to develop a positive relationship with the platform, with the developer relations team. Because if I'm a creator and I have a problem, if I know somebody at Epic or at Roblox that I can pick up the phone or email them and say, hey, this happened, can you help me? That is so much better than having to go through basically a bot or somebody who barely speaks English on the other side of the country to try AI to try
call
to fix
support.
it.
You text right in support, and it's some AI bot.
Exactly. So I encourage everybody to try to maintain and develop relationships within the platform.
Great advice. Early on, you still see it in a lot of creators that have issues or problems, and they go straight to social media, right? And this or that, and this or that, and just that. I mean, I did that kind of early on too, and I don't know. I may have jeopardized some early on relationships I could have had with then if you do have a direct contact or just the proper channels. Like even for Fortnite, for instance, there's a Discord that they are looking at, and you can voice your concerns or opinions even if you don't have a direct contact, But no, a good point. And just anything in business, I think in general, the least amount of enemies you can make is the goal, right? I mean, it does, just because right now, this year, in 5 years from now, doesn't mean that maybe there is some business you guys can do or something happens. Like, it's just, it's good practice. Honestly, that was a great tip.
Yeah, thanks. And, the other thing is the platforms want their creators to be successful. Yeah. Because the more successful the creator is, the more money it drives to the platform. They're not intentionally making things hard for the creators. It could be a mistake on their end, or there could be some reason that you as a creator don't realize why they have to do it that way.
Yeah, oh, for sure. I mean, and honestly, on that question too, as I was a top programmer in this space early on, it's just like when things broke in your game, it made us better developers. And I've said this on this podcast. I knew 5-10 different ways to fix things because of it. I mean, not to mention, I think it's still in beta. So like, I'm sure legally there's whatever cover there, but like it just, what happens is now when something does break, it actually benefits me because I know how to fix it immediately and my game's back up there. And the other teams are still scrambling to try to get up there. So that whatever, shining a light on maybe a positive, but also it is frustrating. And look, if I'm making lots of money, millions of dollars, and update breaks your game, it is really frustrating. So I get both sides, but
yeah, for sure.
Okay, I want to talk about like support for small creators now. So not every creator has a lawyer ready to call, right? Well,
this is one of my favorite topics, actually, and one of the reasons why I love working with small creators.
Amazing. Hey, now you got someone to call, maybe. But, so where can people turn if they can't like afford one?
Okay,
afford a lawyer, things like that.
Before I answer that, what I'm gonna say is my advice to small creators is you are basically a startup company, and your money is best spent developing your game and working on your project and not spending it on legal fees. Like,
Mhm.
you don't want to have these perfect legal documents and corporate structures, because most startups fail, right?
Yeah.
Wait till you get some success before you really do it. But there are a couple of exceptions to that. There's some low-hanging fruit which has enormous bang for your buck, and that will benefit you enormously throughout the whole process. Okay. The first one we talked about before, which is your name. When you choose the name of your game or your studio, Google first and see if anybody else already has that name. Okay. Yeah. And think about whether you can use a fanciful name that can be trademarked. And honestly, you can ask ChatGPT or Google, like, what should I avoid for trademarks? And it'll give you great tips about like how to choose a name or not. It's not very complicated. So number one, be thoughtful about the name you choose. Number two, and this is the most important, you need to have contracts with anybody who is working on your game that says that either all of the IP that they create belongs to you, or that it's done under work made for hire. This is like magic language. If you don't have these things in your contract, even if everybody knows that you're supposed to own it, or there was a handshake, or you agreed to it on Discord, the creator by law when I say the creator, the person building the game or doing the code or creating the asset, they are deemed to own what they create unless they sign something that says, I am assigning all of my IP in this to somebody else. The reason why that matters is if you have a very successful game and it turns out you don't have these contracts, the person that you hired to make it might be deemed a co-owner of all of the IP. Okay. Or they might be deemed to have given you an implied license to use it. Okay. Neither of those things are good, because now you may have an obligation to either pay them money for your game going forward, or they may assert that they have control and ownership over what you're doing. So these are called an independent developer contract. I can write one for you. There's lots of examples on the internet. It doesn't have to be complicated. Have this agreement. And part of the reason why it matters is, we saw, for example, Greasy just sold his game to a big video game company.
Yeah, Gearsy?
Gearsy, yeah. Gearsy sold
so Gearsy just sold his game. Yeah,
to Gaijin.
Okay.
So for many companies, their goal is not just to have a successful game, but is to actually sell the game to a big company and make a ton of money. Or to sell pieces of your game to other people and make a lot of money. It's kind of like startup companies. The goal is, I'm going to create something great and then I'm going to flip it to like Microsoft or whatever. Before any company is going to buy your game, they're going to want to know that you own the IP. Okay. And if you have all of these people who worked on your game that don't have contracts, they're not going to want to spend much money buying it, because they are afraid that it's almost like having a cloud on the title of your house. They don't want to buy a game where there's all these potential claims that are hanging out there. So again, it's very easy to do. It's not expensive. Have a independent contractor agreement with the people that you work for or work with. And the people doing the work should be happy to do it, because that contract also explains that they get paid for what they do. So it protects everybody.
Okay. No, makes sense. No, it's something you definitely should be thinking about. So stay on this topic. Like, how do you verify if a lawyer is legit though before hiring them?
Yeah, that's a great question. So, it depends what you're hiring the lawyer for.
Yeah.
Most of the stuff that creators are doing, what I would recommend is that you have a video call with the lawyer and see how much the lawyer understands about your work, right? Does the person know what Fortnite Creative is?
Yeah.
Do they know how payments are made? Are they familiar with the industry? So that's not law per se, but it makes it a hell of a lot easier to work with your lawyer if they understand what your business is, right? And there are a lot of lawyers out there. Do you vibe with this person? Do you trust them? Do you like talking to them? Those are, you shouldn't have to work with somebody that you don't get along with, or that you don't like, or that you don't trust.
Great answer. I can attest to this. Early on when I was starting my businesses and stuff, I got with a lawyer, and he knew business stuff, but like he always had to like go look it up or go ask somebody about specific game things. And I didn't have a warm and fuzzy, you know what I mean? And then Now, on top of that, like, I think you're just leaving yourself in the wind for certain back end thing or things they're just not even going to think about the cover. That, I mean, that you've mentioned just in this podcast, that things I know that my lawyer didn't know about or think about, or you know what I mean? So
Yeah.
I think it is really important to find somebody that you vibe with, but also understands the space.
And when you talk to the lawyer and you interview them, you should ask them things like, how long will it take you to return my phone call or return my email, right? For part of the value that I provide is I respond to people immediately when I can. Sometimes I'm busy, but I like to respond immediately, even with it just like, hey, I got your email. I'll get back to you in an hour. Because nothing is more frustrating to me than when I've hired lawyers for myself when it takes them a while to respond. And also, I know the speed of video game stuff is they move really fast.
Yeah.
The second thing is my practice, if I'm in a dispute, for example, is I share every single communication that I have with the opposing counsel with my client. And I don't typically send out anything without my client authorizing me to send it first. So, for example, I will say, I'm going to send this email to the lawyer. Is this okay? Because I want to make sure that my client is fully informed and on board with everything that I'm doing. You know, there's all sorts of legal, surveys, which is most clients, they don't know whether or not their lawyer is doing a good job legally or not. But what they do know is they get pissed off if they're not being communicated with. So, fast communication is really important. And then also, I'm on Discord because that's where my clients are. They are on Discord.
Dude, that's crazy. I don't think I've ever met a lawyer on Discord. That's insane.
Yeah, there's a few of us.
Okay.
Yeah, I had to explain to my law firm what Discord was. I was like, it's kind of like Slack for kids, Yeah. Now, it's funny because now email seems so old and slow now that I'm on Discord.
No, for sure. I mean, it's just direct messaging.
Yeah.
Now.
So, I mean, for example, but that's it. If your lawyer is on Discord, probably familiar with the space.
Yeah, there's a good one. That's so funny. Last question I got on legal talks before we jump into the last few questions here. But it's around false DMCA takedowns. Do those ever have consequences? That's been happening on our platform.
Yeah, it's a scourge. It sucks. The answer is practically no. Okay.
Yeah.
So in theory, a DMCA that's made in bad faith there can be legal liability for that. It's a very high burden and very, very, very rare that it happens. So, I have had clients get DMCAs from fake lawyers. So I had a client who got he got a DMCA and he said to me, I think this is fake. And I was like, so the lawyer, what are you talking about? This is real. He's like, no, I looked up the URL and it's like newly registered. And I really think this is, and I was like, okay, I'll call the lawyer. So I looked him up and I called him and he was like, no, I did not send this.
Better call Saul.
Yeah, it was truly a completely fake DMCA. We called the platform and explained to them that this was fake and it wasn't processed. I've also had the experience of, so you know how the DMCA process works, which is you file a DMCA, you submit a DMCA, and the opposing party has an opportunity to submit a counter notice. If they submit a counter notice, the platform will put the game back up in about 14 unless the original complaining party files a lawsuit. Okay. So I had a case where we submitted a DMCA, we got a counter notice, and so I told my client, listen, it's going to go up or you got to file a lawsuit. So we filed a lawsuit. I contacted I had the email address on the counter notice and I emailed them. I said, hey, we filed this lawsuit. And they were like, I don't know anything about this. I did not submit this counter notice. Okay. They're like, that's not me. I've never played this game. I swear to God, this wasn't me. And, it was a completely fake counter notice. And so we went to the platform and we were like, listen, they said this is fake. We're going to dismiss our lawsuit, but you need to keep the game down. Yeah. And they agreed. Now, this person may have been lying about the fake counter notice.
Yeah, just hoping someone would take it down and not fight it.
Yeah, I have no idea. But the reality is that it was actually good for my client because now we didn't have to deal with a lawsuit. We got to go straight to the platform and say, hey, this is all, keep it down.
Yeah. Wow. No, this is good. This is really good information. And it's happening a lot to creators, and especially just, again, these are just new creators. They don't understand it. Probably get really scared. Like they don't know what to do in this situation. And yeah, I don't know, that this is kind of sucks, but also.
Yeah, it does suck. I mean, that's the reality. It sucks. You know, the system was set up before UGC.
So the next question before we wrap up is, what's the one legal mistake you see creators make over and over?
It's no contracts or ChatGPT contracts. Sometimes a ChatGPT contract is worse than no contract because it puts all sorts of wacky stuff in there.
Yeah.
ChatGPT can be a great resource, and I have seen ChatGPT contracts where I was like, wow, that looks like as good as if a lawyer wrote it. But it's really only as good as the person who's inputting the prompts knows. So I would say if you can get a lawyer to help you with your independent developer contract or buying and selling games, I do think that there's value there.
Yeah. Great advice. Great advice. And if anyone else wants to keep the conversation going, where can creators follow you or reach out to you if they need your help?
Yeah, so I'm on Discord at Adam Starr Lawyer, 2 R's. And then that's my social media for everything. LinkedIn, Twitter, YouTube, Instagram. I think I'm even on TikTok. It's the same. It should be the same Adam Starr Lawyer for all of it. I'm very easy to get in touch with.
Amazing. I'll have all those links in the description so you guys can find them there. Cool. Adam, look, this was, I think, one of the most important podcasts we've had on this show. You shared an insane amount of knowledge. And yeah, I wish I could be like this could be your intro into UGC. First thing you should watch and learn about is law around these things. And thank you so much for all.
It was a pleasure. This is awesome. I really appreciate you having me.
Of course, man. Well, maybe we'll see you on another episode. We may have to have you come on again if something really cool comes up in the community or something. But man, thank you so much.
Absolutely. Anytime.
Big thanks for Adam Starr for coming on and breaking down the legal side of gaming worlds. Make sure to go check him out. I have all his links in the description. If you're watching on YouTube, hit the like button, drop a comment, and subscribe so you don't miss the next one. And if you're listening on any of the podcast apps, please make sure to leave us a positive rating. It really helps out a lot. I will see you in a fortnight. That is 2 weeks. And as always, don't hate, create.